3, 2, 1, start. Miss Choitali Bhattacharya, learned advocate appearing for the state respondents submits that having accepted the appointment and approval in a post of graduate teacher, the petitioner cannot turn back and claim honors graduate scale of pay. Stop para. According to Ms. Bhattacharya, the order dated 8th February, 2010 passed in WP number 6173 within bracket W of 2008 did not restrict the consideration of the petitioner's claim by the respondent number 2 on any particular issue in as much as it could be explicit from the said order that all points were left open to be dealt with by the respondent number 2. Stop para. According to Ms. Bhattacharya, the petitioner had not categorically defined the period during which she was granted the benefits of honors graduate pay, and the absence of such specific abatements renders the petitioner's claim to be vague. Stop. Furthermore, the Assistant Inspector of Schools in course of hearing of the matter before the respondent number 2 had categorically stated that no order was issued by the respondent number 3 towards grant of honors scale of pay to the petitioner. Stop para. Ms. Bhattacharya further submits that the grant of honors scale of pay to the petitioner is also not permissible under the staff pattern of the concerned school. Stop para. I have heard the submissions made by the learned advocates appearing for the respective parties, and I have considered the materials on record. Stop. A perusal of the order dated 8th February, 2010 passed in WP number 6173 within bracket W of 2008 reveals that the Honorable Court had categorically observed that if the respondent number 1 comes to a finding that the petitioner made the disclosure in her application for appointment as a teacher in school in social science group in geography that she was an honors graduate, her honors scale of pay shall be restored and arrears shall be paid. Stop. However, if it is in the negative, reasons shall be given. Stop para. In the impugned memorandum dated 6th July, 2010, the respondent number 2 had quoted in paragraph 8 within bracket A the application made by the petitioner for the concerned post, and the same reveals that the petitioner did disclose her honors qualification in the said application itself. Since the BA Part 2 examination at page 46 of the writ application reveals that the petitioner passed the honors examination on 14th August, 1997. Stop. Ms. Bhattacharya had also not disputed the fact that the petitioner disclosed her honors qualification at the time of application for the concerned post. Stop para. As the matter was relegated for consideration to the respondent number 2 only on the limited issue as to whether the petitioner had disclosed her honors qualification at the time of application for the concerned post, and that the respondent number 2, having ascertained the said fact to be true, could not have rejected the petitioner's claim. Stop para. The argument of Ms. Bhattacharya to the effect that the staff pattern of the said school does not permit the honors scale of pay to the petitioner is not sustainable, inasmuch as under the ROPA rules, 1990, there was no restriction towards grant of higher qualification pay on the basis of the staff pattern of the school, and that the said government order dated 4th September, 1998 cannot override the provisions of the relevant ROPA rules. Stop. Furthermore, as admittedly there are 3 sanctioned posts in the social science group, and as only one teacher is enjoying the postgraduate scale of pay in the said group, and as between the petitioner and the other teacher in the said group, the petitioner holds the honors qualification, the said government order dated 4th September, 1998 does not debar the petitioner to avail the honors scale of pay. Stop. It also needs to be pointed out that in the impugned order, no specific ground was taken to the effect that the entitlement of the petitioner to avail the honours scale of pay is not justified as per the approved staff pattern of the said school. Stop para. The pendency of the appeal against the judgments referred to in the impugned memorandum dated 6th July, 2010 had been cited as a ground towards rejection of the petitioner's claim, but the said judgments are distinguishable on facts. Stop para. In the case of State of West Bengal versus Souvik Ghosh, reported in 2008 within bracket 1 CLJ 810, the writ petitioner was appointed in terms of the provisions of the West Bengal School Service Commission Act, 1997, and that the state authorities cited the provisions of West Bengal Schools within bracket Control of Expenditure bracket close Act, 2005 in urging that the petitioner was not entitled to higher scale of pay. Stop para. In the case of Santanu Tirki versus State of West Bengal and others, reported in 2008 within bracket 2 CLJ within bracket Cal 514, the writ petitioner acquired the higher qualification in the year 2004 and admittedly subsequent to his appointment the post of assistant teacher. Stop.